you've compiled some stats. You did some reporting for me, and I appreciate it, as it relates to the first-degree reckless homicide conviction. Are you in a position to kind of relay some of those numbers? It's really fascinating in terms of the number of convictions in Wisconsin under that top count. Now, this is very specific to the top count, right? We won't know what other charges unfolded with the homicide, right? Like in this case where we have other victims. But you have some stats. You want to kind of go through some of these numbers that I think our viewers would appreciate?
Yeah, it's interesting. So in Wisconsin, as well as Minnesota, you can request data regarding sentences that have been imposed for similar charges. And it's a very helpful tool for defense attorneys because you're able to look at historically, if someone is convicted of this offense, what sentence did they receive? You can also then look at their case, so the complaint, the charging document in the case, the indictment, to determine, all right, how are those facts different or similar from my case? And then you try to distinguish. And so here, I know statewide in Wisconsin, since 2003, there were just shy of 1,100 charges of first-degree reckless homicide or second-degree murder. The stats compile those together. And so it's 1,094 specifically. And 8 of those cases happened in St. Croix County, so the county that we're dealing with here for this case. Of that, 713 of that 1,094, they were sentenced. So those people either pled guilty or were found guilty. The remaining matters either pled to a lower offense, had the case dismissed outright, or they were found not guilty. And of that 713, Paul, 711 of them were sent to prison. So that means only 2 received probation. So when I indicate that defense counsel should ask for probation, again, realistically, they know these numbers. These are great defense attorneys. They've done their homework. So they know that only 2 out of 713 convicted of this offense have received probation. So the likelihood's very, very low. Additionally, when you shake that out, we know that 695 of that 711 received a sentence of 10 years or greater. And so the statistics don't break it down to 20 years or more, it's the 10. But we know that 695 out of 711 received more than 10 years of prison. So realistically, those defense attorneys know, and the state also could have done this research and could get that information to say, Judge, probation isn't something you should consider.
And, again, differences between Minnesota and Wisconsin in sentencing, the sentencing guidelines, but it's almost in the statistics create the guideline here.
Right, and yeah, Minnesota's guidelines are much more strict in terms of they tell the judge, here's a very tight range, and that's based solely upon the criminal history of the defendant and the severity of the charge. In Wisconsin, the judge has greater discretion. They're not tied to that small box, that small window of numbers. In Minnesota, a judge can go above or below based upon what are called departing factors. But here, Judge Waterman has that complete discretion. So I would anticipate that attorneys for both sides are going to be looking at these numbers and asking the judge, to consider it. Here, we also know that Judge Waterman has not imposed a sentence for this offense since 2003. So we don't have historical data based upon what this judge is likely to do.
Yeah, so that's interesting. So Michael Waterman has never had a defendant in front of him convicted of first-degree reckless homicide, so this is new to him. And what's interesting, I do think about is he has a jury, and you heard Aaron Nelson in one of the sound bites in my earlier story, kind of right if you joined us about a half hour ago, talk about self-defense being a community standard. So these 12 jurors found, did not believe his claim of self-defense. Judge Waterman, he may have his own personal opinions here, correct, of what he sees in that video or what happened that day, but he has to sentence based on what this jury found.
Right. Even if Judge Waterman felt that legally self-defense applied and he should have been found not guilty because of that, Judge Waterman cannot let that come into play and into his mind when sentencing, because the jury has spoken. The jury has found him guilty. The jury found that self-defense did not apply. So at this point, Judge Waterman has to focus on those 3 factors when sentencing, and that doesn't include whether or not he thinks the jury got it right.
Mm-hmm. Debbie, it's been 4 months since the verdict. I know one of the phases of this time period is what's known as a pre-sentence investigation, where they speak to Miu, they dig into his background, everything. Could you enlighten us a little bit on what might be in that report, and how does probation make a suggestion on a sentence, and Judge Waterman might reference it today in court? What's in that pre-sentence investigation that we'll hear about, and certainly has been filed? It's not a public document. It's filed, but we know it was filed a few weeks ago in advance of the sentencing today.
Yep, and it's not public because it has so much personal information about the defendant. I always explain that a PSI, or a pre-sentence investigation report, it's a book report about you. And so it takes and looks at the defendant from the beginning of their life all the way through. So it talks about their family, it talks about where they grew up, their education, their history in terms of employment. It will talk about military service. It will address potential issues, so it will focus on chemical dependency issues, gambling issues, mental health issues, physical issues. It truly is a comprehensive report about the defendant, and it's designed to give the judge an objective look at the defendant versus what is being said by his attorneys as well as the state. So here, probation is supposed to gather the facts. They generally would speak with other individuals as well to verify the validity of what the defendant is telling them. It, of course, includes criminal history. So not only if someone has been convicted of something, but if they have previously been charged with an offense. And it can even include traffic offenses, one's driving record. It truly encompasses everything. And then there's also, probation generally will reach out and ask the victims if they wish to provide any statements to the PSI writer. Here, I would expect that they would indicate that the victims plan on speaking at the sentencing versus submitting in writing through the PSI. And then generally, yes, probation does make a recommendation, but there have been times that probation merely states, here's what the law says. Here's what can be imposed, judge. These are the maximums. It's up to you.
Yeah, and there's 4 months that typically, that it seems a little longer. I'm usually maybe a couple months, but we've stretched out 4 months. I know it's a significant case, perhaps just part of scheduling as well.
Yeah, I would think it's because of scheduling. Generally speaking, about 8 weeks is sufficient for that PSI to occur. And here the defendant remained in custody, so it does make it a little bit easier because probation knows where he's at and they can contact him and meet with him when it's convenient for them versus trying to schedule with someone who's out of custody. But 4 months doesn't shock me, especially given the severity of this offense and, again, the likelihood of significant jail time. If this were a misdemeanor offense, different story. If the individual is sitting in custody, because you don't want to exceed that maximum, and defense would be asking for less.
And just again, I would reiterate all through the the trial back in April when you guys were with us before, was we talked about if he's convicted on the intentional homicide, it's life in prison, he's got to avoid that. He did, but in all reality, with the numbers that he's facing today, Nicolae Miu, he very much, this could be in essence a life sentence for the 54-year-old.